I'm Congressman Alan Grayson, and I represent Central Florida, an area hard hit by the foreclosure fraud crisis. Foreclosure fraud can affect anyone, whether you have a mortgage, are paying on time, have income, or not. The average foreclosure hearing in a Florida court is only 90 seconds. Mistakes are common, and fraud is rampant. Everyone is familiar with dealing with a big bureaucratic institution. What is happening is that these big bureaucratic loan servicers are charging fees inappropriately, refusing to talk to homeowners by putting their calls through to call centers in India, and then foreclosing with forged documents once the homeowner has been drained of all assets and even the will to fight. There's one set of rules for the banks and another set of laws for everyone else. A servicer can ask for fees, it can demand payment, it can send you to one of those call centers in India, and it doesn't have to negotiate. And you now have virtually no rights as a homeowner. Here are 4 bizarre examples. First, last summer, Fort Lauderdale resident Jason Gradensky experienced what has tragically become an increasingly familiar process all across America. His house was sold at a foreclosure sale after a bank notified the Florida courts that Gradensky had defaulted on his mortgage. The foreclosure came as a surprise to Gradensky, according to reports from the Sun-Sentinel. Not only did Gradensky not have a mortgage with the bank that sued to foreclose against his house, he never had a mortgage at all. Gradensky had paid cash for his home. Second, one house in Pinellas County, Florida, saw 2 mortgage foreclosure suits brought against it because the banks didn't know who had title to the mortgage. Third, one victim with a perfect payment record of all interest and principal was foreclosed on because of a $75 contested late fee. And fourth, Tim and Nicole West were victims of a predatory loan. In 2005, a bank threatened to sue the couple if they didn't sign a refinancing offer. Their loan servicer has subsequently raised their payments from $1,900 a month to $5,300 a month, with regular forbearance fees required in the tens of thousands of dollars. Finally, the servicer refused to accept payments from the family in the name of negotiating for a mortgage modification. But instead of modifying the loan, their servicer began foreclosure proceedings. The servicer used fraudulent documents to prove that it had the right to foreclose. Here's how it all happened. Securitizing mortgages was originally a way to take the cost of the mortgage off of a bank's books. From 2005 onward, the securitization chain went out of control, and Wall Street wanted as many mortgages as it could get as quickly as possible and as cheaply as possible. In order to allow it to pull out more fees at every link in the chain, these subprime lenders, trusts, and banks decided to cut as many costs as possible, including the cost of record keeping. They didn't keep good records, and they violated the laws mandating that they had to file records with the county clerk on who owned what mortgage title. Instead, the banks simply digitized mortgage titles into a privatized system called the Mortgage Electronic Registry System, or MERS. And it did the transfers by trading Excel spreadsheets among the banks and trusts, rather than endorsing the notes as required by their own contracts, by state real estate law, and by IRS rules. Today, MERS is the registered owner of a security interest in 60 million properties, or about 60% of the mortgages in the United States. In fact, 97% of the loans originated between 2005 and 2008 are in the MERS system. It appears that on a widespread and probably pervasive basis, they did not take the steps necessary to own the note, a borrower IOU, which means that in 45 out of the 50 states, they lack the legal right to foreclose. Thus, every trust now has questionable legal standing in foreclosures in the overwhelming majority of states. In addition, their records were poorly kept, so servicers are basically guessing that they have the right to foreclose when they do foreclose. Obviously, the banks do not want to grapple with the consequences of trillions of dollars of securitized mortgages having no legal standing to foreclose. So they have simply created a system where servicers hire foreclosure mill law firms whose business is to forge documents showing or purporting to show that they have a legal right to foreclose. Some of these foreclosure mills have been featured in the New York Times, and so-called robo-signers, people whose names appear on thousands of affidavits. These appear despite obvious forgeries and overt omissions, and in cases where these people admit that they had no knowledge of what they were signing. The system is so organized that there is a company called Lender Processing Services which allegedly has created the means to systematize this fraud. Lawyers use the LPS system to request which affidavits and documents they need. LPS then has document mills where they can magically make an authorized vice president of whoever you need and send you backdated signed documents saying that you have the right to foreclose. Courts at first refused to believe this level of rampant fraud even exists, but more recently they've started to sanction fraud against loan servicers. Here are some examples of signature forgeries used on documents filed with the courts. These are 4 clearly forged signatures of document mill employee Linda Green. Here are 6 signatures of Christina Huang. And here are 3 obvious forgeries of Taiwana Thomas. Finally, this is a mortgage assignment filed with the recorder's office in which the foreclosing firm forgot to put the name of the assignee. So they instead put bogus assignee. The filing firm simply forgot to change the template for whose home, which family's home, they wanted to take. This is a factory of fraud. Servicers don't make money through routine servicing. It's a break-even business. They make their money on foreclosures at $6,000 for each foreclosure through their fee. When you combine the incentive to foreclose with systemized fraud, it's rampant lawlessness. Fraud is now a big business, and sanctioned in part through the government, as both Fannie Mae and Freddie Mac are shareholders in MERS. We are approaching the point where the easiest way to make a buck is to steal it. The only way to end this plague of foreclosure fraud is to make sure that crime does not pay. I'm Congressman Alan Grayson. Thank you.